Good morning, counsel.
Good morning, and may it please the court. My name is Ryan Schiff, and along with Beth Eisenberg, I represent the plaintiff, a disabled senior citizen who has lived without incident in a Boston area rest home for more than 2 years. A highly qualified medical expert has determined that the care he receives at that rest home is precisely suited to his needs, that any lower level of care would expose him to severely dangerous consequences, and that he should remain at the rest home in order to preserve his safety and health. Despite this acute need for care, Section 178K2E makes it a crime for the plaintiff to live an otherwise law-abiding life at the rest home because he is registered as a level 3 sex offender based on offenses he committed nearly 2 decades ago. As applied, this statute violates the plaintiff's state and federal constitutional due process rights and his right to be free of cruel and unusual punishment. We have carefully identified 2 fundamental liberty interests that this statute infringes upon. The first is his right to seek and obtain necessary medical care without undue interference from the state. And the second...
Excuse me, are you saying that this is the only place he could get this kind of treatment?
Yes, as a matter of fact, this is the only place where he can receive this treatment. And I'm sorry.
Who found those facts?
I'm sorry?
Who found those facts?
So, we filed this case directly with the single justice session of this court, and it was reported here by single justice, Justice Cordy. And the way that came about to be reported to this court was that we filed a motion for a preliminary injunction. He held a hearing in February on that motion, and he indicated to the parties that he was likely to report the case to the full bench and inquired of the parties whether there were any disputed issues of material fact that neither we nor the defendants identified any. And he also raised the question of whether some kind of agreed upon statement of the facts would be necessary, but he indicated they didn't want to burden the parties with that if it wasn't necessary. And never did the defendants indicate at that time that anything more was needed, that kind of agreed upon statement of the facts was needed. And I think we do have to keep in mind that we filed this action at the end of August of 2010. So this case has been filed for just about 8 months. On the first page of our complaint, we indicated that we did not anticipate that there would be any dispute of material facts. And during that time, the defendants had every opportunity to answer the complaint, to conduct discovery, and they did not do either of those things. Instead, they waited until almost an entire month after Justice Cordy had reported the case to the full bench, and then filed a motion seeking to stay the case in front of the full bench and to conduct discovery. And even now, they haven't pointed to any facts that are actually in dispute, any historical facts. Instead, all they've pointed out are places where they draw legal conclusions based on the facts that are different than the ones we draw.
But you start with the factual conclusion that this is the only place, the only place in the whole state where he can get whatever treatment.
It is the only place where he can, and the reason why is because he's indigent. He cannot afford. There is no legal prohibition on him getting home care. He can't afford home care. So as applied to him, this statute prohibits him entirely from getting any of this kind of care. And these are facts that certainly are not in dispute.
Can he get home care? Is he eligible for home care?
He certainly is not eligible for having it paid for, not to mention that he isn't before he ended up in the rest home after being severely assaulted on Christmas Day of 2008. But he was homeless, so he had no home where he could obtain the care.
But under the state's plan, I assume he's eligible for the state's medical plan. I don't remember the name of it, but that doesn't pay for home care?
Well, we have submitted an affidavits indicating that it would be no other possible place for him to get this kind of care, that the rest home is the only place where he can get this care. And the defendants also did have an opportunity after Justice Cordy addressed their motion to stay the proceedings to submit additional documents or additional exhibits that could have said, here's some place where he could get this kind of care, and they haven't done that.
Now, are you saying that this law is facially unconstitutional, or simply that there must be an individualized balancing of risk to other rest home persons versus medical psychiatric need?
Ours is an as-applied challenge. What we're saying that as applied to this person, this man who, as I said, his only sex offense conviction took place almost 2 decades ago, did not involve the type of population that is served by his rest home. And there's no indication in the 38-page Sex Offender Registry Board decision that he poses any kind of risk to the kind of person who lives at this rest home, that as applied to him, it violates his constitutional rights. It violates, his fundamental rights to seek and obtain necessary medical care, as well as his right to be free of state-created dangers. And the reason that it violates his right to be free of state-created dangers is that because if he were stripped of his rest home care, he would be driven back into homelessness, and he would face the same kinds of risks that he faced in 2008 when he was homeless. And at that time, he was severely beaten while staying in a homeless shelter here in Boston.
Now, the rest home he can live in, I gather, because he can receive public assistance to live there.
That's correct, Your Honor.
So if for some reason they changed the law because of budget cuts and said we're going to cut our public assistance, would that be a constitutional violation for him?
No, it would not. Well, it certainly is not the argument we're raising now. We're not raising any argument that they have an affirmative duty to provide him with this care. What we're saying is that they can't come, find him in this place of safety where he is getting precisely the care that he needs, and forcibly remove him from that place. And the two reasons why, first reason why, is because he does have a right. He doesn't have a right to get health care. This court has made that absolutely clear. The state does not have an affirmative obligation to provide him with health care. But what they can't do is go and find him in a place where he is getting precisely the care that he needs and forcibly strip him of that care.
What is the constitutional standard that we apply here? Is it a fundamental right?
Absolutely, it's a fundamental right. It is a fundamental right to seek and obtain necessary care. And this fundamental right... I thought you just said
that we don't recognize that right.
I was trying to draw a distinction, and I'm sorry if I didn't do it very artfully, between what this court has said does not exist, which is an affirmative duty on the state to provide you with care, versus the fundamental right to go out on your own and seek and obtain medical care. And this is a right that has been recognized in the abortion rights cases. The abortion rights cases recognize two separate abortion rights. One is the right prior to fetal viability to obtain an abortion without substantial burdens being placed on that right, and that's a reproductive autonomy right. But there's a second right, and that's after fetal viability, a time when the court has made clear the state's interest in potential life is great enough that abortion can be proscribed entirely, that still abortion has to be available to women if it is necessary to preserve their life or health. And that's precisely what the care that he gets is here. We have an expert report by Dr. Ellison, who is the clinical director of geriatric psychiatry at McLean Hospital. And he says that the care he gets there is, quote, precisely suited to his needs, that a lower level of care would expose him to severely dangerous consequences, and that he should, quote, remain at the rest home setting for his safety and health. That is medical necessity. And because this is necessary care, the state can't come in and strip him of that care.
Is the right to have an abortion a medical right?
Well, there are those two rights. One is this reproductive autonomy right, but then there is, even after fetal viability, when the state could, constitutionally based on that first type of right, entirely prescribe abortion, it still has to be available when it's necessary to preserve the health or life of the woman.
So anybody who needs medical attention that is necessary to, I don't know exactly what it is you're saying, but necessary to maintain their health or certainly to maintain their life, they're entitled to medical attention.
Well, I don't know that they're entitled to medical attention, that the state has to affirmatively provide it for them. But what the state can't do, I think we can think of an example where it would clearly violate somebody's rights. The state can't stand in front of the emergency room doors and prohibit all sex offenders, convicted sex offenders, from going in and obtaining care. And why can't they do that? Because it would be this kind of interference with their ability to go out and do what Article 1 of our state constitution says they have a basic human right to do, which is to go out and, quote, obtain.
If he weren't ill, would he have a constitutional right to go into the nursing home or the rest home?
No, the reason why he has a constitutional right to be there is because he is there in order to receive care that has been deemed necessary.
But do you acknowledge that the state has a legitimate interest in protecting the rights of people, other people at the rest home, from people who have been declared or found to be level 3 sex offenders?
Yes, and if we apply the strict scrutiny standard, what the state has to show is that this is narrowly tailored to further a legitimate and compelling governmental interest, and that it's the least restrictive means of achieving that interest.
If we don't agree with you and conclude that the rational basis test is the appropriate test, what do you say is the reason that the rational basis test fails in this case?
Well, the rational basis test looks to the relationship between the government's interest and the means of achieving that interest. And here, if we apply it to this particular plaintiff, we find somebody whose only sex offenses involved minors nearly 2 decades ago, no other convictions other than those offenses on his record, a 38-page SORB opinion stating that he does pose a high risk of reoffense, but never once, despite having plenty of information in front of the hearing examiner that he was living in a rest home, nothing to indicate that he poses any risk whatsoever against the population that is actually served by that rest home. And in fact, by forcing him out of this rest home, where he lives a stable life, a monitored life, his whereabouts are known, his activities are known, they will actually increase the risk that he poses.
Can you refresh my memory now? Did he present this to the SORB board?
Yes. His SORB procedural history is a little bit complicated. What happened was that back in 2006, he was found to be a level 3. He was not given proper notice of his right to a hearing, so he just had a hearing.
Well, the notice was sent
in November of last year. Well, what happened was it was sent to an address where he anticipated living after he got out of incarceration. An SDP petition was filed. He was found not SDP, but in the meantime,
he didn't get the
notice.
Uh-huh.
So he
asked for a de novo hearing.
He did.
And he got it.
And
he made these arguments that you're making today.
Well, he had no opportunity to make the argument that this statute is unconstitutional. What the hearing examiner acknowledged that he would be, if he's forced out of this rest home, he won't have this structure anymore, and that would actually.
He did make the argument that you make, that the offenses involve minors. They occurred decades ago.
Yes,
he made those arguments.
That's right, but of course the Sex Offender Registry Board makes no determination about who the person poses a risk toward in relation to. So all the Sex Offender Registry Board did was made a general determination that he poses a high level risk of reoffense. If you actually read the 38-page opinion, which is part of the record in this case, there is no mention, despite the fact that he lived at a rest home was so prominently presented to the hearing examiner. There is no mention, not even a word in that 38-page opinion, that he poses any risk to the other residents at the rest home. And there's no reason to think that he does. He's never committed offenses against those people.
So if I could understand, you're not arguing that if he had gone to this particular rest home, knocked on the door and said, I'm a level 3, let me in, and they had said no, given no reason, he would have no claim.
He would have no claim. They could have said, you can't live here, but they didn't. What they did was they actually conducted a very detailed admissions procedure and determined, knowing that he was a level 3 sex offender, knowing the nature of his offenses, that he was a good fit with the place and that they could take him as a resident without posing any danger to any of their other residents. And it is that case-by-case determination that has been determined by the Governmental Accountability Office in a 2006 report submitted to Congress is the best way to protect residents of long-term care facilities from people who've been convicted of sex offenses.
Does the SORB board usually factor in where people live in deciding whether they're likely to reoffend or not?
They do look to, as one of their factors, to stability in a person's life. And we did argue that stability that he had at the rest home is something that is a factor that shows that he is less likely to commit future offenses. And the hearing examiner agreed that that was a factor that indicated that he was less likely to commit future offenses. If this statute is held to be constitutional as applied to him, and the defendants are allowed to kick him out, he will be stripped of that structure, and his risk of reoffense, the research tells us, the SORB's own regulations tell us, will be greater, not less. And that's one of the reasons this is not narrowly tailored.
So how do we save the constitutionality of this statute?
Well, I don't think that the constitutionality of the statute in general is before the court in this
So
case. We've
with
only made
regard to your
challenges.
let's assume you prevail here.
Yes.
Let's assume we say it's not unconstitutional on its face. What pragmatically is that going to mean in terms of the procedures that would be required before somebody could be put into a rest home?
Well, already we have Department of Public Health regulations that do require an admissions procedure, so that certainly would still occur. And this law would still be on the books. So as it may be that as applied to some people, this would be constitutional. Somebody who has actually targeted the population served by
So I
rest
assume
homes.
there would need to be an individualized determination balancing the risk to other persons at the rest home versus the medical needs of the level 3 offender.
Right. To be constitutional as applied to him, it would have to be something less restrictive. And we do know, there's the DPH regulations, but then also within the DPH regulations, there's separate provisions that apply to people who are being sent to long-term care facilities from Department of Mental Health facilities, and they require a kind of enhanced screening. So there would be a less restrictive method of achieving the government's interest. And then also we know that there are other states like California, Oklahoma, Minnesota, and Illinois that have passed laws to address this exact issue that are less restrictive than the one here. This is a categorical, absolute ban on level 3 sex offenders from living in these institutions. Under those laws, the institutions the facilities are given notice of the person's classification.
Did they know, did the people at, is it Pine Hill, did they know that he was a level 3 offender when he applied?
Yes, there's an affidavit from the owner of the rest home indicating that he knew that and that he took it into consideration. And also in that affidavit, as well as the affidavit of the person who runs the day-to-day activities at the rest home, both of them say that he is a wonderful addition, that he's never acted in any way that is inappropriate, and he's been there for more than 2 years.
And does Pine Hill have the retained ability to evict him if he creates a problem?
Actually, under Department of Public Health regulations, both the Department of Public Health and the facility have the ability, indeed the responsibility, to kick people out if they pose a risk to other residents. And
now, counsel,
yes.
your time is up.
Okay. Thank you, Your Honor.
Good morning, Your Honors. Julie Goldman, Assistant Attorney General, appearing on behalf of the state defendants. The report in this case by the single justice was improper under Mass Rule of Civil Procedure 64A. There are 4 scenarios in which a case may be reported. After final verdict, that is not applicable here. After an interlocutory ruling affecting the merits of the case, that is not applicable here. Pursuant to a joint request of the parties based upon an agreed upon statement of facts, that is not applicable here. The only scenario that remains as to how this case could have been reported is to report a question of law with so much of the case as is necessary for understanding the question.
Well, did you ever say anything to the single justice that may have led him to believe that there was a problem here in terms of the facts?
I take issue with Attorney Schiff's characterization of what happened at the preliminary injunction hearing. At that hearing, I was caught off guard by the fact that this case may be reported. I was asked by the single justice if there were any facts in dispute, and I said I had not even had the chance to consider that, Your Honor. I would have to speak with my client and co-defense counsel to determine that. So there was no agreement of facts at that hearing. Rather, I did not come with facts on my side to dispute the affidavits that the plaintiff had put in, only that the SORBs
So did
final
you file
classification
something
decision.
after that to say we disagree?
That's when we moved in this court to stay the proceedings and for leave to take discovery and seek to supplement the record. That was
And time-wise, when was that in relationship to the hearing on the preliminary injunction?
the hearing on the preliminary injunction was at the end of February, and my motion, I believe, was sometime in March. And that motion was denied, but I was allowed 14 days to supplement the record. That 14 days obviously was not enough time to conduct discovery. As to plaintiff's counsel's other representation that this case has been pending since August and there was plenty of time to answer and take discovery, that is simply not true. When this case was first filed, SORB took the action of initiating a classification hearing, which plaintiff contended he had been denied. During the pendency of that classification hearing, his level 3 status was vacated, essentially mooting the case, because this case only applies to level 3 sex offenders. And if the plaintiff was not a level 3 sex offender, this statute did not apply to him, and there was no viable constitutional allegation. So as to the possible questions that could have possibly been reported by the single justice in this case, I can only come up with the propriety of the preliminary injunction, whether the statute is unconstitutional on its face. The plaintiff does not take issue with the facial validity of the statute, and whether plaintiff has stated a claim of constitutional deprivation. In this case, we contend that the plaintiff has not stated such a claim because, as it is clear from the plaintiff's representations and in the brief, it is his indigence rather than the state actions against him that could cause him harm in this case.
Well, if he were not a level 3 sex offender, he could remain where he is. It's only because of the imposition of the level 3 sex offender status that you claim he's barred.
Correct, Your Honor.
And the SORB, I gather from the report, that his presence in this rest home was viewed as a mitigating factor with regard to his dangerousness, that the SORB hearing officer found that he was less dangerous because he was in the rest home that you're seeking to remove him from.
It wasn't the rest home specifically, but the fact that he was in a stable living environment. Yes, that was considered by the hearing officer as mitigating evidence, but the evidence of...
Okay, so if you win, then you, according to at least the SORB hearing officer, you are putting other individuals more at risk than they are now. The
SORB hearing officer did not find that compelling evidence, though. There were risk-elevating factors.
Well, I understand that, but
it
was he characterized as a mitigating factor, something that diminishes the level of risk.
There was that one mitigating factor, and also the mitigating factor of his age was also considered. But the overwhelming evidence was that he posed and continues to pose, because this SORB hearing occurred very recently, a high risk of reoffense, a high degree of dangerousness to vulnerable members of the community.
So how does this play out? If you're right, there's a criminal case, he raises the defense of necessity, and he presents the testimony of the people whose affidavits appear, and the burden is then on the Commonwealth to show beyond a reasonable doubt that there are other places for him to go. You're in the same position right now as you would be then. Where's your evidence? You can't even do discovery in a criminal case.
Your Honor, no criminal case has been brought to date. And when and if such a case is brought, he can raise defenses, whether this statute should apply to him, whether it abridges some constitutional right. But that is not ripe for review here.
Why is this statute not imposing a substantial burden to somebody in his health position above and beyond the other level 3 restrictions?
I'm not sure I understand your question.
Well, I guess it was a poor question, so let me try it again. For somebody who needs rest home care or even nursing home care, if you're a level 3 offender, you can't get it under the statute. That's a restriction above and beyond all the other issues with regard to being in level 3.
That's correct, Your Honor.
Why can we not say that when the state seeks to impose that additional restriction, which may have consequences on issues of health, that there must be an individualized determination by the state that the benefits to the public of taking him out of a place where he may arguably do harm to other residents is greater than the health needs of him?
Because, Your Honor, the statute at issue here, there's a rational relationship between the limitation on level 3 sex offenders and limiting these specific categories of places where they can reside, where aged, infirm, frail people live in close quarters. It's only certain sets of institutions that are precluded, and the legislature's rational judgment in protecting the public safety of those of that vulnerable population needs to be deferred to.
But what if the legislature has said, and I think a year or two ago a sex offender at MGH was arrested, and if the legislature said, you know, we really don't want sex offenders being in hospitals. There are too many people who are vulnerable, too dangerous a place. We say sex offenders may not be admitted to hospitals. Rational basis?
Your Honor, that is not the case here.
Well, I know that, but would that be rational basis analysis, or would that be reviewed differently?
I think you would have to look at the medical need proven by the plaintiff, and in this case, the evidence of that is scant. We're not talking about a hospital situation here. We're not even talking about a nursing home situation here. We're talking about a stage 4 facility, the lowest, a rest home care. The allegations of the plaintiff are that the rest home provides a place for the plaintiff to sleep, provides his daily meals, provides planned activities, and provides assistance with medication administration. These are not medically intensive.
So is it your view then that there should be an individualized examination balancing it, but that you'd win on that, or that there's no entitlement to an individualized determination? I mean, you mentioned nursing homes. Nursing homes is part of the statute.
That's correct, Your Honor.
If this were a nursing home, you'd still be saying the same thing.
That's correct, Your Honor. But this case is an as-applied challenge, not a facial challenge. And the as-applied challenge here on the plaintiff's allegations are that he resides in a rest home and that his medical needs aren't received by this rest home. Rather, he sees doctors outside of the rest home, which he is not precluded from doing. He's not precluded from walking into an emergency room, not precluded from getting services at a hospital, not precluded from maintaining a residence someplace else and having a home health aide come in and visit him, or a visiting nurse. It is not the statute that operates to preclude those things from happening.
But if he has a doctor who suggests that he needs either level 1, 2, 3, or 4 in whatever you call it, nursing home categories of care, he can't get it.
Here the doctor, Dr. Ellison, has said that his current rest home care is appropriate and desirable. Hasn't said that it is necessary in this case.
Well, let me just change it a little bit. Let's say you do discovery and your doctor examines Mr. Doe, and your doctor concludes that he needs level 3 rest home care. So can we put him in a level 3 rest home?
No, Your Honor.
He can't get a certain kind of medical attention that everybody else in the Commonwealth can get.
There are only specific categories of varying degrees of medical intensity of these institutions that plaintiff cannot reside. Again, he is not precluded from residing in an assisted living community, not precluded from residing in a retirement community, not precluded from going to see a doctor or to a hospital, not precluding someone coming into a rented room to provide him medical care. The state is not acting to harm him in that way.
But your brother said, he started off by saying the rest homes is the only place he can get treatment.
And that's a result of his indigent status as alleged, not by operation of this statute against him.
But the state will pay for a rest home. The state won't pay for your other alternatives.
That's unclear, Your Honor. That's the plaintiff's allegation, but it is totally untested. We don't have information beyond the plaintiff's allegation that he is indigent as to what eligibility he has for different state or federal government services.
And would the answer matter?
Not in this case, Your Honor, because
You're saying it wouldn't matter if the only consequence to him being removed from the rest home was to go back to a homeless shelter where he will be beaten?
Well, that could be the consequence, and it is unfortunate, Your Honor. It is not something that the state has created here by limiting the places that he is allowed to live as a level 3 sex offender.
Well, do you agree that he is at least entitled to an individualized hearing for determination as to whether or not he needs level 3 care, and if so, then he's entitled to get level 3 care or level 4 care?
No, Your Honor. The plaintiff here received an individualized hearing before SORB regarding his classification status. His classification status was determined to be a level 3. A level 3 offender means they pose the highest risk of reoffense, the highest degree of dangerousness. And so the legislature's judgment that these high-risk reoffenders should not be able to be housed with an extra vulnerable population in a rest home is...
So you're saying he cannot even make a showing under the rational basis test. He cannot make a showing. It is impossible for him to make a showing that he is entitled to care at a level 4 nursing home.
That is not relevant here under the statute.
So if the answer, if it in fact were, again, I'm not saying we have the facts here to say this, but if we had a level 3 sex offender for whom the presence in the nursing home was medically necessary, and the failure to be in a nursing home would result in his death, the AG is saying it would not matter. He's not allowed the nursing home, he must die.
That is not the case that presents itself.
I know that, but I haven't said it is, but that, as a matter of principle, is the principle you're asking us to accept, that even if somebody will die, that's just too bad because he's a level 3 sex offender.
That is not the principle that I'm asking you to accept.
How can you say it's not your principle if you're saying that you're not prepared to have an individualized determination?
Well, because the SORB hearing officer considered all the plaintiff's evidence that he is proffering here today, but there was not the case that it was medically necessary and that he would die without it. That was not presented to the hearing officer.
Right, of course, because that's not that was not the decision the SORB hearing officer was making.
Correct.
He was making a decision on dangerousness, which he made, which is not at issue here today. But you're saying once the finding of dangerousness is made, that even if the result is death, that is something that we have to accept as a matter of constitutional and statutory law.
I'm not contending that, Your Honor, on this record.
But I don't understand, though, how without individualized determination we can know that's not the case.
That would be a different case, Your Honor, but that is not the case that is presented.
But you're saying there's no individualized determination, so there's going to be no place for those facts to be developed and heard.
The plaintiff has not alleged any facts that would warrant an additional hearing other than what he has already been provided. That's my contention, Your Honor.
Thank you, counsel.
Thank you, Your
Your time is
Honor.
up.